All right. Good evening, everyone. Thanks for coming to the Philadelphia Apartment Network, otherwise known as PAN. If you haven't yet, please come up to the table here and sign in and get your name tag so we know what to call you. Otherwise, you might not like the name we come up with. You never know. My name is Genaw. I'm the organizer of this group. We're a little over a year old now, and by the looks of things here, we finally found a topic a lot of people like. So I'm glad you all could come and enjoy what our guest speaker is going to be talking about, which, as you can see, is private placement regulations. It's an important part of investing in apartments or larger multifamily properties, and there are certain rules and regulations that, as you need to use other people's money to further your investment career, that you do so legally, and we're going to hear about that tonight. So I hope you enjoy our presentation. I wanted to introduce our featured speaker. You prefer Elizabeth or Liz? Liz Sigety with Fox Rothschild's law firm. In fact, she's just right up the road here, as a matter of fact. So there's someone you can work with locally instead of a long-distance SEC attorney. Liz is a partner at Fox Rothschild's, which is, when I looked it up online, it was a national firm. I was surprised. They have approximately 800 attorneys in 22 offices coast to coast. She's the co-chair of the firm's National Emerging Companies and Venture Capital Practice and co-chair of the firm's franchising, licensing, and distribution practice. Liz focuses her practice on a wide variety of corporate work with an emphasis on the representation of fast-growth, venture-backed companies and businesses that wish to expand through franchising. She earned her law degree from the University of Chicago Law School and her BA cum laude from Yale. I hope you had a good time in Chicago. I love that city. It's cold, though. Liz is also managing director and co-founder of the Delaware Crossing Investor Group, which is an angel investor network with chapters in Pennsylvania and New Jersey. In this capacity, she has been investing and advising startup companies in the Pennsylvania, New Jersey, New York, Connecticut, and Delaware region for over a decade. She's also a frequent speaker and writer, and she's here tonight as well in that capacity, especially on issues facing emerging businesses, franchise businesses, and women-led businesses, and serves on numerous committees and organizations in the venture capital and franchise arena. What this tells me is she's very qualified to talk on what you're about to hear, and I'm delighted to have her here to talk to our group. Liz has 4 children and resides in Bedminster, PA. So with that said, I'll sit down and shut up, and Liz, I'll turn it over to you, and please.
Am I on? Okay, good. Thank you for that kind introduction. So this is something that's fascinating to you all, right? Coming in on a summer evening like this to listen to securities regulation. I often speak about venture capital and angel investing, a little more jazzy, but Dennis assured me that you really wanted the hardcore law and regulations, so you're going to get it. It's a bit of a dry topic, so please excuse that, but if you have questions throughout the presentation, pertaining to a slide that I'm on, please feel free to ask, but I will be entertaining questions afterwards as well. So a little bit for the legal warning disclaimer. Securities laws are very complex, so please don't take what's on one of these slides and then think that you know what you're doing for a securities offering. Offerings depend on who the investors are, where they are, what qualifications they have, how big is the offering, how you do the offering. I mean, there's just so many different complexities. There's federal, state filings, the whole thing. And we're going to go through all that. But please do not take this as legal advice. This is just a general, little general educational session. So here we go. Oopsie, I think it did 2. Okay, so you're regulated by the Securities Act of 1933. It has gone through numerous amendments through its life. The one that we will be talking about a little bit that you will have heard about is the Jobs Act. And what the Securities Act of 1933 says is if you offer securities, you have to register with the Securities and Exchange Commission, unless you are a private offering and fall within exemptions. And there are exemptions at the federal level, and there are exemptions at the state level. And many of the exemptions at the state level are different depending on the state. So we'll get into that a little bit. So the state laws are called blue sky laws. There's some history to that, which I'm trying to remember right now. But some judge said something about regulations being as blue as the sky. I'm not really sure. But for Regulation D is the exemption we're going to be talking about under the federal laws. And if you comply with the provisions of Regulation D, then you get a certain exemption. It proves that you have done what you have to do. And at the federal level, you have to file a Form D with the SEC within 15 days, and there's no filing fee for that. That's the one good news. But you have to pay attention. So after you have your first offering, you have 15 days. Otherwise, you violated the law. In some states, you have 10 days. So you have to pay attention to this. So the Jumpstart Our Business Startups Act, the Jobs Act, it was trying to encourage funding of small businesses, and it largely did its job. It was passed in 2012, but there, like so many things that Congress does, it had some unintended consequences. Some of the things that were supposed to be really easy weren't as easy as they seemed, and that's probably why I'm here. So one of the things that Dennis had mentioned that you all were very interested in was the change in the Jobs Act under Regulation D, 506, that allowed for general solicitation. General solicitation means basically advertising. So if you have securities you're trying to offer, money you're trying to raise, you can go out to the general public and tell people you don't know that you're raising money. That was not allowed beforehand. So, and generally that's what a public offering is, but this is within the context of small, still private offerings. We're going to talk a little bit about crowdfunding later. I'm going to gloss over that a little bit. I'm not sure it's really something that's used a lot in the real estate arena, but I will touch on that later. Okay, did I do two? I did. Okay, so there's a new subsection called 506C. Most private placements that you will do, if you will hear people talking about it, will be under 506B. That's the old exemption most people used. 506C still has conditions. A person has to be an accredited investor. I'll tell you what that is in a second. You have to take reasonable steps to verify that each person is an accredited investor. I will get into the details of that as well. And there's other rules and regulations which we'll skip over for now. So what is general solicitation? The obvious stuff. It's an advertisement. It's an article. It's, being out there on the web. That's not actually in the regulation, but there's been a lot of interpretations. The SEC is always sending out interpretive letters about these things, but the internet wasn't so prominent when this was first written. It's seminars or meeting when some people have been invited by a general solicitation. So there's an ad or there's a mass mailing that's inviting you to a conference. And the people who are offering securities and trying to raise money are up there telling everybody about the money they're trying to raise. But they don't really know everybody in the audience. But there's been some new guidance that if you come to a conference and you just tell about your business without talking about an offering, and you're not priming for an offering, and I'll mention what that is probably okay. So you can get up and say, oh, we make widgets, we're located in Ohio, we have 20 employees, we have this great business, and you could say that, but you can't say, oh, and we want to raise $1 million and you should invest in us. You cannot say that. So general solicitation is any website with public access that talks about offering securities. I'll talk a little bit about password protected websites. It's any dissemination of information which conditions the public, this is the real words, conditions the public mind or arouses public interest when there's an offering going on. Sure.
sorry about that, but this is one area I'm particularly interested in. I just put up a website for my business, but I don't offer a specific property for sale. Does that fall outside of these requirements?
You mean a property for sale, or you're trying to raise money from people?
It doesn't put up mention any kind of property that I would be raising money for. All I'm doing is saying that I buy properties, and I will, at some point we'll be looking to attract capital to invest in that. But I don't list any specific property. I don't list any kind of rate of return or anything like that. Do I have an issue, or?
If you are generally describing what your business does,
Correct.
You should be okay.
Okay.
But you cannot offer any specific deal to anybody that way.
Okay, good.
Until they become somebody with whom you have a relationship.
And then also have gone through a lot of the paperwork we're going to talk about, right?
Yeah, we'll talk about that a little bit. So this is, for example, dissemination of information which conditions the public mind. So somebody is up there at a conference. They know full well they're raising $1 million for their business, and they start talking about future earnings, and isn't their business so great, and everybody should be part of this, but they don't actually talk about the offering. That could be interpreted as conditioning the public mind. So this is a facts and circumstances judgment. And it's very hard to say in certain circumstances how the SEC would view different types of presentations. So it's not an entirely clear area of law still. Okay, so pre-existing relationship. Obviously, if people have invested with you before and you've already gone through all of the rigmarole to make sure that they are accredited, then they're pre-existing. If they're people that you've worked with before that you really know, then that's fine. There is also some sort of loose guidance out there that if people are members of certifiable angel networks, like I have an angel group that's been out there for 13 years. We are an angel network that is a member of the Angel Capital Association. We are recognized, we are an actual entity, and you have to go through requirements to be a member of our group. There is some precedent that is okay without having to go through some of the additional requirements that you need if you are soliciting. So there is also, and there's Citizen VC is a no action letter. That is the big no action letter, meaning the SEC put out a letter saying we're not going to take action against these people because they turned people they didn't have a pre-existing relationship with into people that they have a pre-existing relationship with. So the facts of that, which may be pertinent to some of you, is that they had a website, password protected website. People could apply to the website if they were interested in, it's a VC firm that would form entities to invest in startup companies. They would put in some very high level financial information. Then the VCs would interview the people, they'd look into their business experience. They wouldn't actually need certifications, which we're going to get into in a little bit, but over time, they got to know these people. So there's a period of time where they are getting to know these people and their qualifications. They did do credit checks. And the SEC said that you can form a pre-existing relationship. Now, the key is that can't be during the offering. The offering cannot have started yet. You can't meet somebody during an offering and then quickly, form a pre-existing relationship. It has to pre-exist the offering. So that's what that's all about. All right.
Now, I see some, it's a little short for me, sorry about that. I see some organizations actually sending out like some squeeze, having like squeeze pages or squeeze websites where they're able to push out information to potential investors and put them like on a regular email rotation. Is that a way of seasoning those particular investors and getting them familiar with it? That way they have a running track record or a log of them being provided with information.
So what kind of information are they?
Basically like other investment opportunities, like whether it's an apartment investment or whether it's like a housing investment and they're
And
providing that.
So these
But
people
they're
have
not
been,
specifically talking about a specific investment. They're just providing some information on a regular basis to them, to individuals on, on the company and so forth.
well, if those individuals have invested with them before, then yes, that's fine.
They have not.
I don't know.
I think they're just kind of marketing to them.
If it's general information about what the company does, it's fine. But if they're talking about any specific investment opportunities, I would say no.
Okay.
I don't know.
Yeah,
if
I
that's
mean, it's
clear.
more generalized information, but
Yeah, I mean, like the terms of their offering generally might even be not the kind of thing
Basically-
I'm talking about.
basically what they do, what type of businesses they're looking or opportunities they're looking at, but not naming a specific opportunity. So they're investing in apartments and basically trying to provide some definition and support for what they do.
I mean, that's probably okay. I mean, if I were them, I'd hope the lawyer would look at the exact thing they're sending out because it's a little borderline. But like a venture capital firm will say, well, we invest in life science companies. Yeah, okay, that's fine. You can tell people you invest in life science companies. And
I just didn't know if that constituted them being comfortable and familiar with that organization.
no, that does not
That does
establish
not
a pre-existing relationship. No.
I have a question also. You mentioned that you couldn't go through like converting them into a friend or family or whatever that thing was. You know them already, while you've got an offering in existence. So does that mean what is the definition of knowing that that offering is in existence? Does that mean that you've actually provided that summary of the deal to somebody else?
Yes.
So
It's been offered to someone already.
Okay.
That it's
I
in the
see.
process of being offered.
All right, I understand.
So it doesn't mean somebody else has had to invest in it already. It's if you're starting to talk about it with other people. So now remember one thing. What I'm talking about here is if you are generally, this is the difference between soliciting and not, because the requirements you have to go through are different. They are more if you're soliciting than if you're not. It's easier to do an offering from an investor's point of view if you are not engaging in general solicitation, and I'm going to explain that. So what is an accredited investor? All of these offerings I'm talking about are to accredited investors. An accredited investor is someone whose income exceeds $200,000 a year and who is expecting to continue that. It can't just be a blip. Or $300,000 a year with their spouse, or has a net worth over $1 million. That does not include where they live. So they can't take the equity in their home and add that. It has to be net worth beyond that. Under Reg D, if you offer to just accredited investors, whether it's general soliciting or not, then you can fall within a private placement. In some instances, you can have a certain number of non-accredited investors, but I have to warn you that the financial information that you have to provide for any offering without accredited investors is much more than to just accredited investors, and there's much more risk. So it'll cost you a lot more to put together all of these very specific financial requirements under the securities laws. It's very precise, and probably for what you guys are trying to do, I mean, a non-accredited investor, I mean, they're not going to be able to put in all that much per person anyway. So to the extent you can avoid that, it's a good idea. Okay, so the reasonable steps if you're going to solicit, then you need to go through much greater steps to confirm that somebody is an accredited investor than if you don't. So if you don't solicit, all you have to do is give the person a questionnaire where they self-certify that they're an accredited investor, and you're done. So all I have to do is check, oh, I make $200,000 a year. Oh, yeah, I have $1 million of net worth. And unless you have a reason to believe they're lying, that's it. So if you can stay away from general solicitation, then it's a lot easier to do. What the angel world has not liked about the regulations that have been promulgated on general solicitation, I mean, everybody was so excited, is because they don't want to give to people, especially, you know, CEOs of people that maybe they don't know very well. It's general solicitation. Maybe they don't know these people, their tax returns, or go to their financial advisors and get certifications. You have to actually go through and make sure somebody has all the financial background that they say they have. And I know in my angel group, nobody wants to do that. So we do not accept pitches from companies that have generally solicited because we don't want to do it. We don't want to, nobody in my group wants to give that kind of information. But that doesn't mean, because we look at different companies, many of them, every month, and that would be a real pain in the neck. But for people that are, you know, doing an investment fund and have time to season their investors, maybe it's not such a bad thing. So basically, the reasonable steps, if you're generally soliciting, the reasonable steps to ensure that somebody is an accredited investor that you have to go through are all of this stuff. If it's income, the $200,000, $300,000 test, you have to look at their W-2s, you know, basically all their tax returns, or you have to obtain a written representation by a third party. I should have put that on here, like a CPA or a lawyer or your, you know, investment advisor. You can't represent it yourself. If it's net worth, same thing. You have to really get statements and information about these people. So if you've generally solicited, you have to get this from everybody investing. Like you can't say, oh, I generally solicited the first person and then, you know, the other person I knew already. If you break that line and you engage in general solicitation for a private offering, this applies to everybody. All right? So you can't pick and choose. All right, this is more of the same. So if you already have an investor that have gone through this, you usually don't have to repeat it every single time they buy from you. So this is the reasons not to generally solicit, to avoid the verification. You know, just know your audience on whether you think that would be a problem or not. But if you get the verification, then it is nice not to have to worry about how you market your deal. And also state blue sky laws. Different states have different laws that you have to go through also for this. So you have to be a little aware of that. So the alternative is no solicitation. Rule 504 is only to accredited investors. You can't have nobody who's not accredited, no solicitation, and only up to $5 million in a 12-month period. So you can use that. But the thing about 504 is there's no federal preemption. You'll say, what's federal preemption? Well, that means that you have to go to each state and do a different type of filing in each state. And that's expensive from a lawyer's point of view. Every state has their own exemptions and their own laws. One of the great things that happened about a decade ago is Rule 506. The Fed said, okay, if somebody files under 506, then you can just send the Form D to all the states. Got to pay a few $100s. Every state has a filing fee. They're trying to make money. But you can send the same form to each state. So it's federal preemption saying you don't have to do different things in each state. So everybody does 506 because it's much easier. So if you have investors in 3 or 4 states, you just send the Form D, you send in the filing fee, and you're done. And that makes it a lot easier. And as I said, there's additional financial disclosure if you take advantage of the fact under 506 that you can have up to 35 non-accredited investors. But please, you know, don't take one person who's not accredited, because probably the amount of money that they're giving you is going to end up half of it getting sucked down in legal and accounting fees to apply to the extra regulation. Yes?
Going back to that last slide, can you re-clarify when you can just use the simple questionnaire form?
Sure. You can use the simple questionnaire form if you do a 504, but you don't get the federal preemption. When you do what is called a 506B, so no general solicitation. Simple form, no general solicitation. All that other stuff that you have to collect from investors, general solicitation.
Okay, so the no general solicitation is you've had a pre-existing relationship prior to the offering coming into existence, and then if those two things are fulfilled with a particular individual, you can give them the simple questionnaire form.
Right.
Okay.
And if you market to certain types of angel groups, people you know, or if you use a broker, if you have a certified broker, they can often, do all that screening for you. But that has to be somebody who's a registered investment advisor, not just somebody who, you have to make sure they're the real deal.
Right. Okay.
Liz, I have a question here. Are we on? If you're soliciting using squeeze pages like the gentleman talked about before, nationwide with an email campaign, for example, and you get responses from all over the country, how do you manage that with all the different blue sky laws and all the other things you mentioned?
Well, the blue sky laws are not just for offering. It's if somebody in that state buys the securities. So if you're doing a 506 offering, which I would advise, within the first 15 days after the first person buys, you have to file your Form D with the federal government. But then you have to keep a very careful chart of where all your investors are. And I would try to do within 10 days, when somebody sends you money from Iowa, send in the Form D and the filing fee to Iowa. You have to keep track of it. So it's when they send you the money. It's when they actually invest and when they sign the commitment to invest, the subscription agreement. That's when.
So a follow-up to that is, instead of you actually capturing the money, can they send it to a third-party escrow agent, let it accumulate, and then when you get enough for the project, then accept it and send in all those forms that you just mentioned all at one time?
Right.
Is that a way of doing it? Can an escrow agent hold that money?
Well, that happens all the time, but we usually file the minute the money is put into the account.
Even to the escrow agent?
Yeah.
Okay.
All right, I'm continuing. Offering documents. So what we usually do and what most people do is we put together a simple what we call an offering memorandum and subscription agreement. Depending on the complexity and size of the offering, these can be fairly simple or very complex. So for a smaller offering, what it would encompass is a lot of, all the disclaimers about this is not a registered offering. We're doing this, there's transfer restrictions. For example, when you do a private placement, people can't then invest with the intention of turning around and selling it. You can't flip a private placement very quickly. And there's other things that they put in there. We put risk factors. There's all these awful things called risk factors that makes the investment look terrible. So it'll say, this is a risky investment. You might lose all your money. Awful things can happen to real estate. There can be an earthquake. You can lose your money. There can be, the builder can go bankrupt. You can lose your money. It says all these things. Any sophisticated investor knows that this is going to be in there, because basically, if you tell the investors the things that can go wrong, and then those things go wrong, it protects you in the end. So risk factors are a very normal part of a subscription agreement. It also has a lot of representations by the investors that they are sophisticated and they understand the terms and they've read the document and that they're accredited. We still put that in, even if yourself have to go through the certification process. So then there may be some attachments, maybe something that you guys have put together about your business description and the properties that you're looking at, so that the investors have some information. And then there'd be the actual terms of the investment. If they get some of their money back, if there's a preference, explaining exactly how that is. So there'd be a term sheet, and then probably the operating agreement or LLP agreement will be actually attached. That way they can't say that they didn't understand the deal, that there wasn't information given to them that, where they can't claim later that they didn't get the information they needed. So so that's what the offering documents look at. So it ends up to be a package. I'm sorry. It's my mother. So we put together my firm puts together an execution package with instructions. So you'll send out this, fairly thick thing, and then there'll be a little, 5-pager of what they have to sign. And then it just makes it a lot easier. And when you send out those documents, you should keep track of who you've sent them to. Keep a chart of all the people you've sent them to. If people don't invest, sometimes people like to ask for them back, but in this electronic age, probably have a copy on their computer anyway. So it's just, you just have to make sure to, keep track of it all. Yes, Judith.
If you were sending out something, if they've gone through your qualification process so that you know that they're okay to send a document to, what if they turn around and then send that document to their friends without your knowledge? Should you have like a disclaimer at the bottom of your email to sort of say they're not allowed to do that and it's like against our wishes or things like that?
Yes, I mean, these are confidential documents and they should be treated with confidentiality. It says that in the document. Can you prevent them from doing that? No, but you should tell them not to. And it does actually say that in the document as well.
Oh,
it should.
okay.
It should, but it doesn't hurt to put that in your email. I mean, that's a good point. Okay, so I was just going to touch on crowdfunding. This is something that everybody gets a little confused about, and it's something that's often talked about. Crowdfunding basically is a combination of people raising money or interest in their company and social media. So the crowdfunding you've heard about for so long is product crowdfunding, like Kickstarter. Like you'll get the watch before everybody else. And if you give us a few $100s, and people are able to raise a little bit of money on that. And then what was out there that people wasn't really crowdfunding was accredited investor crowdfunding. So there's all these platforms called AngelList, and there's a lot of them. But the only people that invest through those platforms are accredited investors. So that's not really the equity crowdfunding that got so much press. The equity crowdfunding is that people who are not accredited investors can invest small amounts. Many people can invest small amounts in a company, but they're still getting equity. I'm not going to go through all of this. I think you're going to have access to this, and it probably isn't a good idea for real estate investments. One thing that happens is you end up with a lot of equity investors. Plus, I've had clients who've gone through this, both the accredited investor platforms and the true crowdfunding platforms. It's a lot more work than it looks like. I mean, it was supposed to be simple, but it actually takes a lot of time to put these types of things together. I would say it works very well if a company is a product-based company. It's trying to get a lot of attention on the internet, so it ends up to be a combination of advertising and raising some money. If you're just trying to get a few people to invest at high amounts, it doesn't make any sense. So these are just all the things you have to do. So
Can I ask a quick question about equity crowdfunding? Mm-hmm. Is there a secondary market for those shares? If you buy the shares or buy the equity, if you want to get out of the deal, is there a secondary market for them?
I don't know. It's actually fairly new. The true equity crowdfunding has only been around. It's only been legal for like a couple years now at the most, and so it's still. I honestly haven't done a deal that is true Jobs Act equity crowdfunding. I have had clients that have used the accredited investor websites, and then it's the same transfer restrictions as there are on any private placement, where people have to hold it for a year or two.
But you don't have to be, unlike the public markets, I don't want to get too hung up on the crowdfunding story, but do you have to be registered the way you would if you were floating an issue on the New York Stock Exchange? Or
the crowdfunding site has to be registered. It has to be a FINRA broker-dealer registered site.
Okay. I
so the crowdfunding portals are, they've gone through a lot to be able to open that portal.
Yeah, I thought it was the Wild West, and anybody could put up a crowdfunding request, equity crowdfunding request.
No, you have to go through a FINRA registered broker-dealer crowdfunding portal.
Okay.
So I've talked a little bit about this already, the blue sky laws. So one thing I do want to touch on, though, is finders. This happens a lot in the startup company world. I represent a lot of life science and technology companies, a lot of quick-growing branded companies like distribution companies and franchised companies. And very, very often, they'll be working with somebody who's going to find them investors. And I'd say at least half the time that person is not actually a registered broker-dealer. So what happens is this person says, oh, I know all these people, I'm going to find you investors, and you only have to pay me if I'm successful. So if I find $100,000, you got to pay me 5%. You got to pay me, $100,000, you pay me $5,000. That is illegal. If they are not a broker-dealer, that is not legal. Now, if you pay that person as an employee $1,000 a month to help you, that's okay, but a success-based fee is not legal. And it happens all the time, but it's real. And the SEC is looking at this more and more. So the risks, let's see, where am I here? Okay, so risks from, what if you do this wrong? What happens to you? What if you don't go through these representations or you use the broker? What are the risks to you if you don't offer correctly under 506 and you're not really exempt? Well, the main risk is rescission. So if the investor is giving you $100,000 and later it's found out that you didn't properly comply with the securities laws, they can ask for their money back. And, this could be much later. Usually it's when the investment's not successful. So often that's a time when it's hard to find that money. They can also report you to the SEC. There can be all sorts of other bad things that happen, but rescission is the worst of it. And sometimes they can also ask for costs and expenses on top of that. You're supposed to make them whole. You're supposed to put them in the position that they were in before they invested. So it's not a good place to be. Oh, let's see. Okay, this is just more about trying to scare you into not using finders. So there's SEC enforcement actions as well. Yes?
On finders again, because I know that's a new topic for me. I just recently ran across the fact that they even existed. I know you can't give them a percentage of what they bring in. Can you give them a percentage of the deal and have that be legal for them to find you equity investors?
Not if it's based on their success. No.
So they would have to be in on the deal regardless, and then it's just a matter. So then in other words, what you're telling me is there can't be any real incentivization based on how much they bring in.
Right.
No matter how it's structured.
Because the theory, the SEC's theory behind this is it will, if somebody is not properly educated and they're going out there and trying to push people into investments because they'll only be paid if it's successful, that they may say things they shouldn't say, they're not properly, to be a FINRA broker actually takes a lot of time. You have to take tests, go through a whole lot of rigmarole.
Not to be a little cynical, but that sounds like what an insurance agent gets paid to do. And they're not all that qualified often, but their success, they make money when they make a sale, right?
Right.
I hope
there's a lot of commission-based businesses, but when you're, selling the swamp to your grandma, and that's what the SEC is trying to protect against, I guess. There's often investors are putting a lot more up than, paying for an insurance policy, I suppose. Oh, that's me. So, questions? About really anything.
With an investor coming in, if I'm trying to raise, we'll say, $10 million, can an investor take a percentage of that? Is there a limit on how high he has to be where he could just invest into it, or is there like a limit on that? If he invests more than 20%, is there a background check done on that investor if you're syndicating the deal?
I'm sorry, I don't understand the question.
My understanding is that you and I wasn't sure if it's the case, is that if I'm looking to raise $10 million and somebody comes to the plate with $5 million to put into it, then there's a whole other background check done on that person, or can they just invest that in? A certain percentage, when you exceed like 19%, there's a background check done on that person. You have to get more information for that?
I'm not aware of that, no.
What about Class A and Class B investments? Mm-hmm. Breaking them down, do you have to offer Class A, I guess, when you're syndicating the deal out too?
Well, Class A and Class B is just a name used in a private placement. Often I have one right now, which has Class A and Class B investments, but we've defined that what that is. So the Class A is, in this instance, is the new investors coming in and putting their money into the development project. They get a preferred return. So the Class A is basically the preferred return for the investors. The Class B is the management interest. So if you're managing an interest, managing a project, then maybe you get some sort of carry at the end of the day. It's called carry or whatever you want to call it. But after the investors get paid and they get their preference and they get their money back, then maybe there's something for, the people that have put the project together to compensate them. And that might be the Class B management interest. Also, Class A and Class B may have different control rights. So the Class B, the management interest, really has almost complete control over the project and what happens, whereas the Class A members have extremely limited voting rights. So is that what you're talking about? Right, exactly.
My question is,
but you can call it whatever you want.
my question's on an established relationship. In this day and age of electronic communication, and I'm just asking a personal question. Say I'm looking to raise money for an apartment complex, and I've been on a professional email forum times 20 years, and I sort of know these people, and I haven't met all of them, but I've met enough. Is that an established relation if I just want to go, hey, everybody, I'm doing something outside my field, and is anybody interested in this project? I mean, some of them I know that would be an established relationship.
But the thing is, you don't know all of them on that email list.
Correct.
So the fact that you sent that email to people that you don't know breaks the whole thing.
Okay.
No matter who ends up investing.
So I'd have to itemize each email address that I do know, and if I send it to just them, it would be okay?
It depends on how well you know them. And I can't, I mean, I should show you some of these letters. They're, I mean, do you really know their financial capacity and their business acumen? Do you have a reason to understand that they are sophisticated investors?
We're all professionals in the same field, and it's up on a doctorate level. So yes, I have a general idea of how their business runs.
I just to be the devil's advocate.
Okay.
So just because somebody's in the same field is not enough.
Okay.
Because somebody is educated, I don't know if that's enough either.
Okay.
But if you really, have you sat down and really talked to these people? Do you understand their business? When they talk about turning somebody from a relationship, turning something into a pre-existing relationship, when you read the SEC, it talks about very specific steps and time of getting to know the people and interviewing them about their business background and all sorts of things. So, and doing the credit checks and everything else, and that's how it turns into a pre-existing relationship. Well, if you've known somebody for your entire life and they're your good friend and you know what they do, that's pre-existing. So I'm sorry not to be able to.
I mean, some of these people I've known for 15 years. We've met. Do I know their tax return? No.
No.
But there's been enough of a conversation that I haven't.
I mean, I'd argue that's probably good enough.
Okay.
Can I promise you if it was ever, if somebody sued you later on and said, hey, she didn't know it, she offered it to me and she was soliciting and she didn't get my my background. It's
I'm just trying to figure out when you can give them that letter that basically says, are you an angel investor or accredited investor or not?
Right. Yeah, it's a questionnaire, basically.
So if I know them enough, can I give them a questionnaire and that's okay?
Yeah, the questionnaire would be attached to the offering memo with all the information about the offering, and then they'd certify they're an accredited investor by just checking the box.
I guess that's the question. When do you know someone well enough that you can send the offering, send that letter, and even though you may not 100% know their business, is that a relationship or that's still shaky?
If you say you've known them for 15 years and you have met them and you've had, dinner with them, it's probably enough, but it's not. I wish, there's nothing written that goes to every single scenario.
I'm just trying to figure out what the relationship is.
Right. So just being in the same industry group is probably good enough, not good enough. But if you've known this person for a long time and you feel like you have a really good sense of them, it might be.
So I have a question here, Liz. For some of us, we're thinking about setting up a multi-stage email campaign step 1, step 2, step 3, maybe 4, however many steps there might be. Are there any sample templates of such email campaigns out there on the interwebs somewhere that we could take a look at to get an idea of what's an appropriate language to use for each one of those stages? I mean, or is every campaign a unique campaign that has to be approved by an attorney? I know it's a self-serving question, but there
So
must be
stages, what are the what kind of stages?
The first stage would be, hello, my name is George, and we're in the general business of buying apartments. Are you interested? And then whatever the next stage would be, here's the questionnaire. I don't know. I don't even know what the stages would be, but it's a 3 or 4 stage campaign, email campaign. Do such templates exist out there that we could take a look at to give us some idea of what language we need to use for those campaigns?
Well, I mean, if you're approaching people you don't know, I just
Yes.
argue that's general solicitation right off the bat, unless you have a cooling off period where you actually meet them and get, do the credit checks. I mean, I have copies of the letter where it shows the detailed steps these people went through before they actually started offering to these people to make them pre-existing relationships. But I'm not sure about a template. But if you have a facing web page that just describes your business, and if you get some sort of marketing list and you send out emails that describe your business, that's fine, but you can't offer or ask them to invest.
So that's stage 1. Then
Okay.
they say, yes, I'm interested. Right. Now,
Then
what
you
do
have to get to know them personally.
That's more than filling out a form?
Yes, that's more than filling out a form.
Would the form be stage 2?
Well, they could fill out a form that they're interested in getting to know you better. You can review that form, and it would probably have them self-certify that they're an accredited investor.
Okay.
But after that, I wouldn't say the stages are by email anymore.
Okay, so the first one is, are you interested in general in apartments? Yes.
Right.
Okay, second stage would be, do you fit these qualifications? Check, check, check. Yes. Next stage is getting to meet them personally.
Yeah, meeting them. Maybe you're doing credit checks. You're understanding, you're talking to them and interviewing them. And in this letter talked about interviews that the VCs were conducting for all these people, getting references and background checks, but they didn't actually get their, tax returns, I guess is the difference.
Okay, so for step 1 and step 2, are there such templates out there that we could use just to get some idea what the language has to be?
I mean, there might be, but I don't. Basically, you just have to describe what your business does. I can show you guidance about what describing a business is versus describing an investment opportunity.
Okay.
I do have articles about that.
And when you say show it, do you physically have paper, or is it on the website? Or?
I could look in my briefcase. I do have a couple articles about
Okay.
this that I brought.
Would that be something that Dennis can put up and make available to all of us?
Sure.
Okay.
Yeah, I can follow up with you, and then you can send it out.
If you want some sort of template for it in particular, you can also look up the Series 63, which is the exam to be a financial advisor, and they will have specific regulations for things you can include in marketing material that highly, highly indicates that it is marketing material and not general information. So if you want to pull out free study guide exams for the 63, it will definitely be in there in specific regards to what you can and can't include.
What, for the FINRA exams?
Mhm.
I've never seen a FINRA exam, but I'm sure that they are pretty thorough.
Liz, in a situation where I was raising money to purchase a small apartment building, but strictly between friends and family, long-term friends and family, do all people investing need to be accredited, every single member, or is it?
They do not. So how much were you? Is it under $5 million?
Under $5 million.
Okay, so they do not all need to be accredited, but if they're not, you're supposed to be putting in more detailed financial information, and there is very specific guidance about what that needs to be.
Okay.
And so that's why people stick with accredited.
Okay. Also, in that case, for purchasing a small apartment building, all those filing fees and just making sure I am following the SEC guidelines, what would your fees be for something like that? Oh, maybe overseeing that. Is it something like?
Am I on?
Can we turn the video off before I start talking about it?
Let me just refer you to the front table here, where Liz has kindly provided a bunch of information on her firm and her business card. And if you're interested in exploring a more professional relationship beyond the context of this meeting, I would suggest, Liz, you're willing to take phone calls to do that?
Yeah, and I'll be hanging out.
Okay, thanks, Liz.
I'm being recorded.
Save your butt. Uh-oh.
I'm brand new, so
Come on, Larry. Up to the mic.
I'm looking to borrow $50,000 from a friend that I know for a long time. So I would do the 506, have that paperwork, and yes, to fund the project, to purchase and property.
All right, so so you're saying she is basically offering to fund your business, right? I mean, and it's just between the two of you, and you've known her for a long time. Okay. In some ways, technically, that is offering a security. So you're investing, but people do lend money to each other all the time without having to go through this. If it's not really offering securities to people for an investment. I mean, you would put together a promissory note, and you should document the security.
What's the $50,000 going to be used for?
Yeah.
Use the microphone, please. I mean, please.
Oh, properties. She said properties.
To live in or to rent? A flip. Okay. Well, I don't want to solicit, but there are people that will lend money for flips, and you don't need any.
Right. Yeah.
No. You can just see me at the end of this meeting, and that's all you need to do, and it's done. I do it every day, literally every day.
I mean, just, it might be better to do it from a third party. Sometimes now I'm getting into friendship advice.
I'll become your friend if that helps.
So is everyone in this room now a prior relationship with me?
With you?
Yes.
No.
Okay, I was curious.
Well, I don't know much about the Philadelphia Apartment Network and what the qualifications are to enter the group and if there's screening. I mean, for example, for my Angel Network, only people that know each other can bring people in. They do go through a membership process. They have to sign a membership agreement. They have to pay membership dues. They have to yearly certify that they're accredited investors. I mean, we have procedures. So it's not.
So we just showed up for the first time today, and I was soliciting everybody in the room for money. I can't do that.
Right.
Gotcha. Perfect. Thank you.
Well, if you take money from anybody, yeah.
Somebody asked the question before about how much did it cost. So I'm going to tell you a story about when I did a private offering. I think I even mentioned it to you at one time. This was many years ago, and I needed to raise $1 million to start a business, and we went through the whole private offering process. And by the time we were finished with all of the costs, and probably this was higher than what you guys charge, but there are other costs involved. We ended up spending about $60,000 all in for all legal costs. But
we will be less than that.
I think you're a little bit lower. Yes, I'll be glad
Well,
to
assuming
share it
there's
with you
not
later.
any other regulations that are affecting, sometimes there's other things that people do, but just for the offering part, it's a lot less than that.
Well, this was a lot. This was the whole package. Right.
Sometimes people feel like they have to write a whole prospectus that looks like a public offering document. You don't really have to do that if you're working with just accredited investors. I mean, you have to give out the information. You have to be transparent. You have to let people ask questions. There are things you have to write, but there are times when I see things that have been written by lawyers, and it's just, you'd think they were doing an initial public offering. You don't really have to go quite to that level.
So if you're going to do an offering, should it be done under which kind of business entity? An LLC, a sub S, a sub C?
Oh, this is a very complicated question.
Pennsylvania, Delaware, New Jersey, the Cayman Islands? I mean, what's the best? What's the best? What are the answers to those questions?
All right, so
it depends.
The answer is it depends, and the tax laws are changing, and my firm is going through a very intense reevaluation of these types of things. But there's issues with corporations. This doesn't really apply to real estate, but if, for example, a corporation's issuing equity to like a technology or another fast growth company, and somebody holds on to that for 5 years, you can be exempt from capital gains. So you got to think about that law for a corporation. LLCs, however, have passed through taxation. Sometimes investors like to get the losses if there are losses in the beginning of a cycle. And then there's only one level of tax, and that in the past has been a very good thing. So we use a lot of limited liability companies for these types of offerings. So probably that's something strongly to consider. I think in the real estate world, it's been LLPs, but people are using LLCs much more, limited liability companies much more than they used to. They've become very normal.
So years and years, I'm sorry, go ahead.
No, you're fine. Hopefully my question is a little bit easier than everybody else's.
Great.
There's three terms that are getting thrown around here. Is accredited investor, I hear sophisticated investor, and I also hear a general investor. Are you using general investor and sophisticated as the same person, or using sophisticated and accredited as the same person?
Okay, so under the securities laws, originally a private placement was called a 4-2 private placement. So for any of you who've been around and have sort of had conversations, the general law under the Securities Act of 1933 is Section 4-2. And if you're a sophisticated investor under 4-2, then theoretically it's a private placement. But they put in a safe harbor called Regulation D that if you do certain things, nobody's going to argue about whether the person's sophisticated enough. So accredited investor is sort of a safe harbor to being a sophisticated investor. Does that make sense?
Yeah. Okay.
So Reg D is just a way to check the box and make sure you're doing everything right.
Okay. All right. Because I've seen a lot of PPMs that actually offer sophisticated investors. You're more like an equity investor and not accredited. They don't do a background check.
Right. I mean, I used to work on Wall Street in New York, and we're not asking, the institutions that were investing in my big companies to, check any boxes. You just know that they're sophisticated. There's a certain level at which you just know somebody is okay. And if you don't want to comply with Reg D and just say, hey, this is just so obvious that these people are qualified that we're not going to worry about doing the safe harbor, then it's okay. But I would say these are for your 9-digit type, much larger offerings. And also if you're offering a minimum of $100,000 a person, that often, everything feeds into the perception that these are only sophisticated, qualified investors. But
thank you.
Oh no, it's the mutual fund guy.
Yeah. One quick question for you. Could you just avoid all of that if you borrowed that money from a business? If you have the investor put their money into an LLC or some other business entity and then lend you that money?
But the investor is investing in the LLC. Who's LLC? I mean, who's offering?
Let's say you start an LLC. Okay. And Larry starts a fund. Right. And your LLC lends Larry that money. Can you avoid the
LLC is the investor.
Correct.
Right. The LLC is the investor. Accredited investor, I've been only talking about individuals, and maybe that's my fault. But if you have an LLC that's investing in something else, they have to have a $5 million net worth to be an accredited investor. There's a big list of trusts, and when they're accredited, when an LLC is accredited, it goes on and on. So accredited investors aren't just individuals. It's entities have to be accredited as well to invest. An LLC if it's something that was formed for the purpose of the investment, all the members of the LLC have to be accredited. So you can't have this pass through. You can't hide behind an entity. Right? Okay, does that make sense? I hope I'm making sense.
And so the end of the road risk that we're avoiding is if this person gives us this money and the investment doesn't turn out how we told them, they can't come and say, you know, I wasn't really an accredited investor, I didn't know what was going on, therefore give me my money back.
Yeah, you didn't do the filings, you didn't, you know,
Right.
You misrepresented to us. There's also just a general claim, even if you go through all, you check all the boxes, if you lie to them, that doesn't work either.
Right.
So you have to make sure to tell them all the material things about the investment, give them a chance to ask questions.
But who else is coming, is the government coming at us too for, hey, you didn't file this?
If you're doing repeated offerings and you're in this business, yeah, they could come after you themselves because they're going to want to stop you from continuing. And they look back for, 5 years, 10 years to people's history. And if you have violations, then that's something that's public. So yes, the SEC will come after you, especially if they think you're going to keep doing this.
And if there are no violations, then they don't know. There's nothing for them. It's not like a tax audit or anything like that. So, oh, you didn't file your forms. You owe us $300 over the past.
No, there's not a, if you didn't file the Form D, you have to pay $300. But there are some, on state level, there are some penalties. So I just had to have, I had a client who, it was out west somewhere, had not filed on time. And I actually called and said, okay, can you send the money back? And can you reoffer it to somebody and let them reconsider whether they want to invest? Right. And then send the money back if they still want to invest. And we had to go through all of that because this state has been issuing penalties recently. Some state securities commissions, they haven't done anything in ages, and others have become more active, depending on, it's just like tax audits, trying to enforce their laws.
My question was in regards to two entities doing, one entity lending to another through a joint venture agreement in terms of the private lending. Does that, are you familiar?
I mean, these are both sophisticated. Neither entity's been formed for the purpose of the investment.
Correct.
They're just entering into a
joint venture where one is lending the other with a set return. And they create a joint venture for that transaction.
If they're two sophisticated entities in the business, I think that's just a loan document.
So I have a question if nobody else does. So years and years ago, because I'm an old person, I remember.
But debt can be a security. If somebody's offering a lot of loans to a lot of different people, just because it's not equity doesn't mean it's not a security. Okay, sorry.
So years and years ago, because I'm an old person, I remember things like oil well tax shelters, okay, if you remember that. So given the new Trump tax plan, are there any tax shelters built into the tax plan that could be built into one of these offerings, built into an offering?
Well, I mean, for example, I talked about the capital gains issue, qualified small business stock. That's something that has now been permanently put into law. As far as other tax shelters, I'm not a tax lawyer or a CPA, so I'm not sure I'm qualified to. There are, there's angel tax credits at the state level. There's some in New Jersey. There's some in Maryland. You got to look at your state to see if you qualify for that. But those tax credits can be something that startup company investors really value. Once again, it's something they would file for on their own tax returns. But
so recognizing that you're not a tax lawyer,
yeah, I'm just not aware of the oil well tax exemption.
So if there's a real estate offering made, obviously people are hoping for the increase in the value of the property. and also the depreciation, which I assume gets passed along. Are there any other things that can be passed along that makes the investment valuable besides the two obvious things, given the new tax laws? I'm not asking you a clear question because I'm not even sure I know.
The new tax laws were passed very quickly by Congress.
Yes, we know.
And I have been going to seminars about them, and most of what I'm hearing from the tax attorneys are they haven't figured out what this really means yet. That the regulations and interpretations, that it's going to take the IRS years to catch up to explain exactly what's happening. Mortgage laws, for example, they limit the tax deduction on the amount of mortgage. The interest tax deduction on mortgages is now capped at $750, but there's certain circumstances where it might not even be that, and they're trying to figure out what that means. So there's just a lot rolling around, and I have not had time to completely absorb it yet. But I have a whole bevy of tax lawyers that, right now there's. I send provisions and everything too, and I have an offering like this right now that I just sent to my tax attorney because I'm not sure exactly whether there's something new that we should have in these documents with the new tax laws. So I'm having him look at it because I'm worried that we're going to miss something. So I'm sorry, I can't answer the question specifically though.
Well, with that said, outstanding job. Thank you for covering everything.
You.